Thank you, Mr. Chairman. We're talking, of course, about the direct cost of administering the enormous job that all of you have made all the more so by Dodd-Frank. And I submit that another aspect of considering the cost of the SEC, if you will, is how much what you do requires from our issuers. That's obviously the other half of the equation, if you will, because for every regulation that you must promulgate and assure that it's carried out, obviously there's a whole team on the other side. You know well, you've been on those teams, that has to invest resources in compliance. And of course also consider the liabilities that are conferred by every new layer of regulation with which they may find one or another snag. I introduced the topic of Section 953B earlier, and I would be eager for any of you to comment, and I think Ms. Cross, you may be the first in line, regarding the way in which it was written, regarding what would seem to be fairly conspicuous deficiencies in the way in which it's specified as it stands now, in terms of trying to determine ultimately, you know, the big concept is this really useful to do? You know, how do we, I mean, we can get into the weeds about specifics, but is it ultimately going to provide useful information? So whatever you can comment about the challenges of getting through those specifics and about whether or not it really should supplant the existing requirements regarding compensation disclosure. So please.
Thank you very much, Congresswoman. I have to start by saying that the decision of whether this information is useful is a policy call that is included in the Dodd-Frank Act. Our job at the SEC is to implement the requirements of the Dodd-Frank Act in a manner consistent with investor protection and all of our other missions, including a good cost-benefit analysis and weighing the concerns that the registrant community, the corporate community is raising about this particular proposal or this particular requirement. We have not done a rule proposal on this one yet. It does not have a deadline under the Dodd-Frank Act, and we're doing the ones with deadlines first. We have an email box where people have been putting in their comments in advance, and we've had many meetings with registrants. People are very concerned about this provision being costly. I have to say, I wish I had something else to say, it's very prescriptive how it's written in the statute. It doesn't actually give us leeway. It is written so that it has to be in every filing, it has to be every employee, it has to be compensation as calculated under Rule 402 the day before the Act was signed. I don't know that we have leeway. So we always want to implement the rules in a way that is workable, but we have to do what Congress has directed us to do. And so I will say now, I have concerns about how workable we can make this.
Yes, ma'am. And I appreciate your candid assessment. May I challenge you just that little bit further to ask, because it is a legitimate question, you know, we're the Congress, we can change these things. Would it make sense for us to undertake a change in that requirement? Perhaps even, I'm not asking you to advocate for its elimination necessarily, but would it be reasonable to endeavor to change it in ways that would presumably eliminate the relative, the ratio of burden to benefit, if you will?
Well, I'm not speaking for the Commissioner, I'm speaking for myself. I think that if Congress wants to have this pay ratio disclosure, the spirit of it, there are changes you could make to it to make it less difficult. I don't know that those would be consistent with the policy behind it. So using the median employee is a complex thing. An average is not as complex.
Right.
Using the 402 calculation instead of W-2. There are a lot of things you could think about that might make this more workable, but I do want to be careful because the policy, I don't want to undermine the policy if Congress has in mind what
And I
it did.
respect that, and I don't want to put you on the spot in that way, but I respect all of you as experts. You know, you have lived these things, and we need to heed your thoughts on these matters, because if we don't, then good intentions lead to stasis at best and to harm at worst. And there's a tremendous devotion of resources that could really go into computing a median, assuming, or determining a median, assuming that we could actually successfully define all the ways in which employees are designated, in which types of compensation are fit into the calculations. I mean, it just a quick reading of it.
It's a complex requirement, and I think that, again, we've been working on all of our Dodd-Frank rulemaking initiatives to balance where we can the benefits and the burdens. In this instance, it is a very clear requirement, and absent other direction, I believe that it is what it is.
Yes, ma'am. Well, I'm very grateful for your guidance in that regard, and I yield back my time, Mr. Chairman. Thank you.